Hello inventors, I'm Karima Gulik, registered patent attorney and engineer and the principal attorney at Innovent Law. And today I wanted to talk about one of the most frequent questions that I get about provisional application. Should you get a provisional patent application? How much information do you need? What does it cost? And what do you need to file? Let's dive in. So one of the main questions that I get is, should I get a provisional application or directly file for a non-provisional patent application? And the answer, as always, is it depends. So before we get started, let's dive into what is a provisional patent application and what does it entail. What is a provisional application? First of all, there is no such thing as a provisional patent. I've seen people going on Shark Tank saying that they have a patent because they filed a provisional, or people telling me that they have a patent and that they're patented because they filed a provisional. A provisional application is an application that gives you a priority date, essentially. In and of itself, it never becomes a patent. In order for it to become a patent, you have 12 months from the time of filing to convert to that provisional patent application, file a non-provisional application, claim priority date of the provisional application, include in there the serial number of your provisional, and this needs to be done within 12 months of filing the provisional. Now, that non-provisional is the one that actually becomes a patent. The USPTO never looks at provisionals in substance. So when you file something, no one is looking at it to tell you whether it's good or not. You file it, you submit it, you get that priority date, and now this is your earliest priority date. The only time the substance of it becomes relevant or becomes important is if during when you file the non-provisional and a search is done and they reveal some sort of prior art or things that show that maybe your invention is not as new as you thought. Now then you go back to your provisional and you show that, look, I came up with this invention and this is my earliest filing date. So that's where the provisional in substance comes into play. It's also worth mentioning that you cannot file a provisional application on a design patent. Provisional applications are only relevant to utility patent applications. If you're unsure about the difference between the design patents and utility patents, make sure to check out our video here on the difference between design and utility patents. Also, if your invention is best protected by a design patent, it might not be worth filing a provisional. You might be better served with just a design patent directly. What are some of the benefits of a provisional patent application? So, has a few benefits which are definitely worth looking into. It is one of my favorite tools, especially when used properly, and it can help you make most of a limited budget. So if you're at the early invention stages, you don't have that much money to spend into patent protection, you're not sure whether your idea is going to take off, whether you're going to make the killing that you wanted to, so it's best to file a provisional, test the market, see if this idea is going to be bringing in the money and it's worth investing more in the non-provisional patent application. So before you go spending a lot of money on your intellectual property protection and filing for the non-provisional, test it out. Get a provisional, see whether this is as good as you wanted it to be, whether the market is responding as well. It's also a great tool if you're still making changes and tweaks to your invention. Filing a provisional or even a series of provisional applications as you're doing the improvements is definitely worth it. When you file that non-provisional or that conversion, you can then refer back to all of the different provisional applications that you filed. Another benefit of filing a provisional application is if you don't have time to sit down and get the non-provisional ready in time. So for example, if you have an investors meeting, or if you're about to go and disclose your idea at a seminar, at a trade show, or things like that, filing a quick and dirty provisional application, by quick and dirty I mean still having all of the information, all the enablement requirements that you need in there, but at the same time it's not as final as the non-provisional. So file that, go to your trade show, come back and work on the non-provisional conversion. A lot of times investors want to see a patent pending or a provisional application filed before even discussing. Since most of them don't want to be bound by non-disclosure agreement, it's best to have a provisional patent application in place, something to show them, knowing that you're protected and knowing as well that they do not have to sign a non-disclosure agreement, because most of them will not. Also, knowing that you have spent some time and effort thinking through your invention, either coming up with a prototype or not, but having enough details in there, having some drawings and a flushed out invention as shown in a provisional application for filing. Now, what are some of the drawbacks or disadvantages of filing the provisional application? Well, one is it is delaying your patent application. So if you do not convert it until 12 months timeline, or when that conversion is due, you're looking at an additional 12 months where your patent is not getting examined by the USPTO. So in that sense, it might delay things a little bit. But if you're not ready to hit the market running and you're not ready with that invention completely as being as finished as and complete as you want it to be, then filing that provisional is still your best bet. Two, it's an additional cost. So a lot of firms will not credit your provisional to your non-provisional. Some of them will, because we're essentially using that same work that we're doing in the provisional towards the non-provisional application. So firms like ourselves here at Innovent Law will credit a portion at least of your provisional towards your non-provisional because you're using a lot of that same work. So that might be another consideration when looking for the right patent professionals to work with for filing and drafting your provisional application. Another inconvenience is if you're still in the very early stages of the invention. So sometimes I have people calling me saying that they have an idea and it's just that, an idea in their head. They have not sat down and taken the time to write it down, to make little sketches, to really flush out that idea. In that case, it's probably too early to file a provisional application. So before you contact a patent professional, make sure to sit down and take the time to write down your idea, flesh it out, how to make it, and try to get into as much detail as possible in order for you to help yourself and help that patent professional help you draft the best provisional application possible. Now, another drawback is foreign filing. If you file as of today, September 1st, 2020, you get that date as priority filing. Now, if within a year you're filing the non-provisional, it's also at that time that you need to think about filing your international patents or PCT, because you get 12 months for those from the earliest filing date. What do you need to include in a provisional application? This is another one of the frequently asked questions that I get is, how much information do I need in there? Well, as much as you can get. And the more thorough your write-up is and the more enabling it is, the better and more solid of a priority date and of a foundation you're having. So a few things that you need for the actual filing. You need a specification, and that's usually that entire write-up. Ideally, the provisional application looks no different than your non-provisional application. So if you're not sure what that looks like, do a simple Google patent search and for similar ideas and similar inventions and see how much detail goes into those. That's the kind of level of detail that you want to have in your write-up, ideally. Your patent professional can definitely help you get there. You need drawings, although not a requirement. It is almost impossible to have an enabling disclosure or have a write-up that is thorough without having drawings. So even one or two hand sketches can go a very long way. If you're filing as a micro entity, then you definitely need to have that certification of status file along with your application, and that there's a form on the USPTO website for that. If you just search the micro entity certification status for income basis. No claims are required, although some foreign countries state an application with no claims is not complete, so it's always best to include a few general claims. Again, just because there are no formal requirements does not mean that you should not do this to the best of your abilities, that you should just jot down a few ideas, maybe do one or two sketches and send it off, because that will probably not give you the proper support that you need and can hurt you in the long run, especially if you think that that date is your filing date or your priority date. You start disclosing and then you realize that within those 12 months you're not ready to file that non-provisional, you decide to file another provisional. Now you've disclosed your invention without having proper support for it for more than 12 months, and you can definitely hurt yourself and become prior art against yourself. So make sure to take proper care in drafting your provisional patent application. And just remember, a provisional application in and of itself would never become a patent. And in order for you to convert it, basically what you need is you need to file a non-provisional utility patent application and just refer back to the application number of your provisional application, and the filing date of that. And make sure that this is done within 12 months of filing of your provisional patent application. So for example, if we filed a provisional application today, September 1st, 2020, you have until September 1st, 2021 to file a non-provisional and keep that priority date. I hope this helps. And just remember, the right idea will fly. Until next time. And if you have any other questions or comments, please make sure to drop them in comments and question below. Make sure to hit that subscribe button so you get notifications every time we drop some patent and trademark content, and to make sure that you're best positioned to protect your intellectual property rights.